I want to welcome you all to the federal permitting panel discussion. My name is Lingxi Chenyang. I am an associate professor of law here at SJ Quinney. As Eric, one of our keynote speakers, mentioned yesterday, planning and coordination in the beginning is essential to better permitting, which is essential to the energy transition. We have a fantastic lineup of speakers across industry, government, and academia who will dig into this question of what the federal government's role is in this permitting process. So I'll introduce them and then take questions at the end. Those of you who are in the audience here and online, please feel free to use the Slido format to submit your questions. Okay, so first we have Jamie Pleune, as we all know, is Associate Professor of Law Research at the SJ Quinney College of Law, and also the Interim Director of the Law and Policy Program here at the Stegner Center. Prior to joining the faculty, she was a shareholder at the law firm Richards, Brandt, Miller, Nelson here in Salt Lake. She studied law here at the University of Utah, where she graduated Order of the Coie and then clerked at the Utah Supreme Court. Jamie's research focuses on environmental review, permitting, climate change, and conservation. And Jamie will talk to us about what we know and don't know about NEPA and permitting. Next, we have Amy Coyle, who is Deputy General Counsel for the White House Council on Environmental Quality, or the CEQ, which oversees implementation of NEPA, the National Environmental Policy Act. Prior to her position at the White House, Amy spent a decade leading the environmental policy and federal Indian law practice areas within the U.S. Department of Transportation's Office of the General Counsel. Amy will talk to us about recent regulatory changes to NEPA. Following Amy, we have Rebecca Higgins, who is the Chief of Staff for the Federal Permitting Improvement Steering Council, where she assists in the management of nearly $100 billion in large-scale infrastructure projects. Rebecca previously served as a senior policy advisor for the U.S. Senate Committee on Environment and Public Works, where she led the committee's transportation and environmental permitting programs. Rebecca will discuss implementation of the FAST 41 bill and other issues arising from NEPA reform. Following Rebecca, we have Ted Boling, who is a partner at the law firm Perkins, Coie in Washington, D.C. Ted advises clients on renewable energy projects, resource development, transportation, and infrastructure. Ted previously served at the federal government in various capacities. He was at the White House Council on Environmental Quality and the U.S. Department of Interior and the U.S. Department of Justice in both Democratic and Republican administrations. He has been deeply involved in the environmental review process and authorization of federal infrastructure projects. Ted will talk to us about NEPA amendments in the 2023 debt ceiling bill, the Fiscal Responsibility Act, and what that means for federal permitting. And last but not least, we have David Adelman, who is the Harry Reasoner Regents Chair in Law at the University of Texas School of Law. David teaches and writes in the areas of environmental law, intellectual property, and climate change. Before academia, David practiced at Covington & Burling and was a senior attorney at the Natural Resources Defense Council in Washington, D.C. David will talk to us about what we know and don't know about the NEPA and the permitting process. So Jamie, take it away.
Okay. I apologize that you all have to hear me twice in a row, but we're going to talk a lot about NEPA during this panel, as you can expect, but we're also talking about permitting, and so I'm going to set a little bit of the stage today. So the first thing I want to do is distinguish between NEPA and permitting. These two phrases often get conflated when we're talking about permit reform, and I think it's important for a critical discussion about how we can improve permitting to distinguish between these two things. So NEPA is the National Environmental Policy Act. It is an act that is intended to facilitate decision-making by informing officials and the public about the environmental effects of an action. It's often referred to as a look before you leap statute, but I think it's also really important to think of it as a disclosure requirement. And if we think about disclosure requirements, they're often really risk reduction strategies. So in the financial realm, it's very normal for us to use disclosure in order to reduce risk. Essentially, we're doing the same thing in the environmental field with NEPA. And finally, notably, there is no substantive mandate with NEPA. It's a procedural requirement. Now, permitting is different, and there is no official definition of permitting. So I'm going to suggest a few. We'll start with Black's Law, which is a certificate evidencing permitting a license. So if we think about that, that actually makes sense. It is saying you can do this, you're allowed to. So the difference between permitting and NEPA is there's a substantive requirement to comply with a standard. Commonly with environmental cases, it's going to be the Clean Water Act, the Endangered Species Act, the Clean Air Act, things like that. It's a substantive requirement. But I also think it's valuable to think of permitting functionally. So I'm going to suggest my own definition that I have started to think about thinking about, well, what do we mean when we think of permitting? Because we're often also using the term referring to things that aren't federal statutes, like a building permit or a construction permit. So permitting is actually a tool for agencies to implement, administer, and enforce laws that were passed by a legislature. And I'm going to say we should also presume that those laws reflect democratic values. So the functions of an effective permitting system are important. And I won't go into each of these elements. You can read them if you want, but I want to really focus at the bottom. One value of an effective permitting system is that it provides clear procedures and standards, it creates certainty for regulated entities, and it enforces a baseline measure of performance. It also evenly enforces standards and avoids a race to the bottom and levels the playing field. So with NEPA and permitting distinguished, let's talk about NEPA. And let's talk about the one thing that everybody wants to talk about, which is how long does NEPA take? And the answer is we don't really know. So the number that you always hear is it takes 4.5 years. And that number comes from the CEQ study that looked at EISs that were performed between 2010 and 2018 across all levels of federal government. And it concluded that the average time was 4.5 years. But it's really important if you look at this graph to notice that 4.5 years is, I wish I had a pointer, but it's towards the end of that graph, and the median is actually 1 year shorter than that, 3.5 years. And then you actually have quite a few permits that, in fact, half, that were completed even faster than 3.5 years. The other important thing, the other important thing about the study, or kind of weakness about the study, is that it only focuses on EISs, which is the most rigorous element of NEPA, but NEPA is not a one-size-fits-all statute. It has, its level of disclosure is tailored to the anticipated effects of the project. And so projects with significant effects go through a very rigorous disclosure requirement. Less significant or uncertain effects, less rigorous, and then understood or insignificant effects have a very quick disclosure requirement. So when we think about NEPA, it's not just EISs, and that's an important point. In fact, only 1% of all NEPA documents or decisions are EISs. Estimated about 5% are environmental assessments, and 95% of them are categorical exclusions. So when we look over the entire federal government, there are less than 100 EISs that have been issued each year in the last 5 years, and only 4 federal agencies issue more than 10 per year. So we, at the Law and Policy Program, we undertook a big study to try to understand a little bit more about NEPA. One of the big challenges is that there's no data out there about all the other decision-making, all of the other levels of decision, or centralized data about how different agencies are handling NEPA. With one exception, the U.S. Forest Service. They have a very large database where they've collected information about all levels of decision-making from 2004 to 2020. And so we were able to obtain access to that database, had more than 41,000 unique Forest Service decisions, and those decisions also indicated what kinds of activities were involved in the NEPA decision. With that, we were able to confirm a few things. One was that within the Forest Service, those estimated numbers of how many categorical exclusions, environmental assessments, and EISs was quite similar to the federal estimate, but slightly different. So 81% of their documents are CEs, 16% are EAs, and 2% are EISs. We also observed that trend of fewer and fewer environmental documents being issued each year is occurring within the Forest Service, with the exception of even categorical exclusions are going down, but only slightly. As you can see, there's quite a dramatic decline in the number of EISs that are being completed. And similarly, there's also a decline in the number of EAs completed. And then we asked the golden question that everyone wants to know: how long does NEPA take? And what we found is that it depends. So these graphs are all 3 levels, graphs of the decision-making times for all 3 levels of analysis. EISs are closest to me, and then EAs and categorical exclusions. And one thing that you'll find very interesting, if you look at these graphs, all 3 of them have the exact same shape. They all have the vast majority of decisions that are made within a relatively short period of time, and then they have a very long tail that drags out. So when we think about this and we put the 4.5-year number in context, we realize that number is right there. And when we use that number to talk about how long NEPA takes, we are ignoring an enormous amount of data. We're ignoring all of this information over here, and then we're ignoring all this information over here. And notably, the information that's over here, which you can see is like a small amount of data, that's where the anecdotes come from, and those are the ones that are often driving policy. So if we focus on the average making decision time, we're ignoring important data about what is possible and also what is causing delay. One also really interesting thing that we observed is that there was not discrete buckets of timeframes based on the rigor. What we found is that often a more rigorous decision was completed more quickly than a less rigorous analysis. So that's fascinating because that tells us that it's not necessarily analytical rigor that's driving timeframes. Because this was a very consistent pattern, and it happened not just between EISs and EAs, but also from EAs and CEs. So we wanted to know, well, can we figure out what makes a case fall on the tail? What causes delay? Why are some of these cases getting bogged down? And I'm not going to go into all the details about the regression model or the things that we found, but what I can tell you is the summary, that we essentially found that there are really 3 big categories of things that cause a project to fall on that tail. And those are agency capacity, which is enough staff to analyze the decision, and also enough staff with the right expertise to handle a particular decision. The next one were delays that are attributable to the operator, so like waiting for information from an operator or a change of plan. And then the third one was compliance with other laws, because NEPA often serves as an umbrella function. And as I said, it's a procedural permit, but also gathering all of that information is often used to facilitate understanding how to comply with the substantive requirements, the permits. So marrying those two is one thing that caused delays, and then permitting coordination. So now the big question is, are these results replicable beyond the Forest Service and beyond NEPA? And I am going to say I think that they are. So the first thing I want to say is let's look at mine permitting. Here you can see that the graph is shaped the same size, and it's a little confusing because that this guy looks like it's bigger, but it's not, because that's all of the permits that took more than 48 months. So if you look at mine permitting, you see that the shape of this graph looks exactly the same as the shape of the graph for the NEPA decisions. And we have two, in 2016, the Government Accountability Office did a study on mine permit delays. And we also have a really big study that was done by the National Research Council in 1999. Both of those studies identified the top causes of delay were insufficient resources, including staff, expertise, funding, technology, waiting for a response for an operator after a vague or incomplete plan was submitted, compliance with other legal standards, and ineffective agency coordination. Here, we're looking at oil and gas permitting times. Now, this is a slightly different graph. What we're looking at is the amount of time that it took a field office to process an application for permit to drill. And so you can see there's enormous variation between field offices. And this is very interesting because they're all applying the exact same law. And the rate of variation goes from 300 days in some field offices to 30 days in some field offices. The Government Accountability looked into this and identified the top three causes of delay were lack of staff, poor data management, and weaknesses in oversight or accountability, essentially coordinating the different experts that had to approve the application for permit to drill. And just to detail that a little bit more, the Bureau of Land Management actually collects data on how much time it spends processing an application for a permit to drill versus waiting for information from an operator that it needs to get that information in order to approve the permit. And as you can see, in 8 out of 10 years, 8 years out of 10, they spent more time waiting than they did working. Finally, we heard about the mining IWG report this morning, and we had a great discussion of permit times that they found in the report. And I will also point out that they identified top three causes of delay were vague, incomplete, or low quality applications, a lack of agency capacity, both qualified staff and resources, and operational changes. So I hope you guys are starting to see that there's a pattern here. And if we think about how we want to think about permit reform or drive permit reform, maybe what we should be thinking about is how do we target these functional causes of delay? It's very easy to think permits can be sped up by having more policy, but policy is not the only thing that is necessary in order to get something done. So if we want to target the causes of delay, these are some of the things we should be thinking about when we're talking about permit reform. First of all, let's ensure that there's sufficient agency staff capacity. Secondly, let's avoid having vague and incomplete applications by making regulatory requirements public, transparent, and easy to understand. And third, let's figure out ways how to foster coordination between agencies and permitting authorities. We have an example of whether or not this works. As you heard yesterday, the Fast 41 process went into operation in 2016. And so we have a little mini pilot project. And what we're finding is that these are some of the most complex projects by definition, they can only get into this voluntary program if they are extremely complex with a lot of different agencies. And despite that, the projects that are coming through this program are being completed much more quickly than the average. So when we're thinking about permit reform, what I would suggest is that if we think about functionality, the functionality of how regulations are implemented, how statutes are enforced, and how we get all of this done, how we build, then we can start to build a permit reform platform and strategy that targets all of the drivers for getting things done.
Thank you, Jamie. Next, we have Amy Coyle.
Good morning. So I'm going to talk to you today about a proposed rule that the Council on Environmental Quality issued back at the end of July. So first, just starting with a little bit of background. So as Jamie stole my thunder and talked to you a little bit about NEPA, it was enacted in 1970 and amended in June of last year in the Fiscal Responsibility Act. It created the White House Council on Environmental Quality to oversee implementation of NEPA, and we issue the NEPA regulations, and then agencies themselves issue implementing procedures consistent with those regulations that customize their procedures to their specific programs and decisions. So as Jamie said, at the core, NEPA is about informed agency decision-making and involvement of the public in that decision-making process. So I'm going to try not to use too many acronyms, but again, environmental impact statements, or EISs, those are the biggest or highest level of NEPA review. They are for proposed actions or decisions that agencies are going to make for projects that are likely to have significant environmental effects. And then categorical exclusions are at the other end. Those are categories of actions that agencies have experience with and have administratively established them in their agency NEPA procedures, and those can typically be applied quickly. And then in the middle is an environmental assessment. Those are for actions where they're not anticipated to have significant effects, or the effects are unknown, and the agency doesn't have a categorical exclusion to apply. Additionally, agencies can mitigate the significant effects down below the level of significance in environmental assessment and issue what's called a mitigated finding of no significant impact, which we like to call a FONSI. So a little bit of history about CEQ's NEPA regulations. So they were first issued in 1978 and were largely unchanged for over 40 years. There was one amendment in the mid-'80s. And then in July of 2020, CEQ issued a rule that substantially revised the 1978 regulations. And so I'll refer to that as the 2020 rule. And then in the Biden administration, CEQ was directed to take a look at regulations that were issued over the past 4 years and propose updates. And so CEQ took a phased approach. So we issued a phase 1 rule in April of 2022 that amended 3 core provisions of the regulations related to the definition of effects and purpose and need, which informs the alternatives that agencies consider, and then a provision related to agency procedures that set the agency procedures as the floor, or the CEQ regulations as the floor rather than the ceiling for agency procedures. And then this past July, as I mentioned, we issued a proposed phase 2 rule. So I'm going to talk about that today. So first, a little bit about the goals that guided us in developing this rule. So first, we are implementing the amendments to NEPA from the Fiscal Responsibility Act, and then looking to provide for an efficient and effective environmental review process that promotes better decision-making, that is efficient and transparent, ensures full and meaningful public engagement, guided by principles of informed science and based decision-making. Actually, I'm reading the wrong talking points, so I'll let you read that and go on to the rule. So first, I want to talk a little bit about the Fiscal Responsibility Act, and these slides have way more than I have time to talk about today, so I'm going to pick a few just to highlight. So first, one provision of the Fiscal Responsibility Act provides a process or allows agencies to adopt categorical exclusions that are in other agency NEPA procedures. And so the proposed rule sets out a process the agencies would follow to adopt these categorical exclusions, and then they can use them and apply them to their own agency actions. And this really promotes efficiency. So for example, where an agency has a new program where they have not established categorical exclusions for those types of actions, but another agency has experience with that and has a similar categorical exclusion, they can now adopt it and use it. And agencies are already implementing this provision, and several of them have issued Federal Register notices to adopt these. So next, another provision I want to highlight is Section 108 of NEPA. So this provides some certainty around programmatic environmental documents. So these are environmental assessments or environmental impact statements that typically do a broader analysis, and that agencies can tier and make subsequent decisions off of those documents. So a couple of examples: out in California, they did a Tier 1 environmental impact statement for California high-speed rail, and the Tier 1 was basically modal choice. They looked at rail, they looked at air, they looked at road expansion. Then they did subsequent tiers where they looked at regions, and then they do project-specific ones. Another way agencies use programmatic documents is to look at a particular resource. So, for example, an endangered species in a particular region where an agency is going to take a lot of action. They do a programmatic review to look at that and then incorporate the analysis by reference into a future document. One big section that we proposed a lot of changes to is one where we're consolidating, or we propose to consolidate, requirements for making threshold determinations about whether NEPA applies. So the Fiscal Responsibility Act included a specific provision about this, and then determining what level of NEPA review is appropriate, whether CE, EA, EIS, what's the appropriate scope of the NEPA document, the proposed action, and then from there, what effects you have to consider. And then the proposed rule restores and updates consideration of the context and intensity of the proposed action, which is really a list of factors that agencies consider in whether or not the action has the potential for significance. Turning to meaningful public engagement and transparency, the proposed rule includes multiple changes to support this goal in the environmental review process. So when developing public engagement and outreach strategies, the proposed rule encourages agencies to tailor these strategies to consider the needs of affected communities, including consideration of the primary language of affected persons and the appropriate format of a public hearing or meeting, while also considering the scope, scale, and complexity of the proposed action. To support additional transparency, we propose to codify the longstanding agency practice to invite public comment when an agency publishes a draft environmental assessment. And we propose to require that agencies provide unique identification numbers for each environmental assessment and environmental impact statement and their associated documents, such as the notices of intent and records of decision, to really help the public and decision makers track the project of these documents from start to finish. We propose to require agencies to identify the environmentally preferable alternative in the draft environmental impact statement. So the regulations currently require agencies to do this when they issue a record of decision, and this change would allow the public to comment on the agency's identification of that alternative prior to their issuance of the record of decision. And then lastly, we are proposing to require agencies to designate a chief public engagement officer to facilitate community engagement across the agency. So turning to environmental and climate change outcomes, we proposed a change to require agencies to to require agencies to analyze reasonably foreseeable climate change-related effects of the proposed action and its alternatives. And this would include both effects of climate change from the on the proposed action itself. I should also mention that in January of 2023, CEQ issued interim guidance on the consideration of greenhouse gas emissions and climate change in the NEPA process to help agencies conduct these analyses. And the proposed rule would also require agencies to discuss any relevant risk reduction, resilience, or adaptation measures in an environmental impact statement. When an agency relies on mitigation as a component of the proposed action, the proposed rule would require preparation of a monitoring and compliance plan to ensure that agencies are appropriately relying on mitigation in their decisions and to address concerns that mitigation measures included in agency decisions are not always carried out or monitored for effectiveness. And then finally, CEQ proposes some updates to various definitions to include specific references to climate change. Turning to environmental justice and tribal sovereignty, in multiple places throughout the rule, it would add language to ensure consideration by agencies of disproportionate and adverse effects on communities with environmental justice concerns and adverse effects on the reserved rights of tribal nations in environmental reviews. So as an example, in the context and intensity factors that I just mentioned, agencies would consider these types of effects in assessing whether their proposed action may be significant or may have significant effects. The proposed rule would also make clear that Indigenous knowledge is a source of high quality information, and in the context of considering potential cooperating agencies, clarify that special expertise, which is one of the qualifiers to be a cooperating agency, includes Indigenous knowledge. CEQ also proposed to add references to environmental justice in multiple definitions, including adding a definition for environmental justice that is consistent with President Biden's executive order on environmental justice. And finally, the proposed rule encourages agencies to adopt mitigation measures directed at effects that disproportionately and adversely affect communities with environmental justice concerns. To support informed and science-based decision-making, the proposed rule would restore direction to agencies to rigorously explore and objectively analyze reasonable alternatives when conducting an environmental impact statement. It also emphasizes use of high-quality information, including reasonably foreseeable environmental trends, such as anticipated climate change-related effects. And many of the changes in the proposed rule are intended to ensure that agency decision makers are well informed, and they tie back to the statutory direction to emphasize professional and scientific integrity. And then lastly, turning to efficient process and regulatory certainty, we are proposing to require schedules for the development of environmental assessments and environmental impact statements and encourage coordination between agencies, project sponsors, and applicants, including placing an emphasis on consultation and concurrence on schedules, as well as early engagement with government agencies at all levels, federal, tribal, state, and local, where they have a role in the action or project. And the schedules are important because the Fiscal Responsibility Act amendments to NEPA set a 1-year deadline for environmental assessments and a 2-year deadline for environmental impact statements. We have also proposed to combine and update the provisions on programmatic documents with the provisions on tiering, which really codifies longstanding agency practices for using these tools and provides more certainty in how agencies can use these tools. There were quite a number of changes proposed specific to categorical exclusions. So we proposed edits to clarify the process for consideration of extraordinary circumstances. So when an agency applies a categorical exclusion, it has to examine the particular action to make sure there are no extraordinary circumstances that indicate that that action may have significant effects. And so we're proposing some additional changes to what was done in the 2020 rule to clarify how agencies can examine whether or not application of a categorical exclusion is still appropriate. The rule also would clarify that agencies can issue categorical exclusions jointly where they take similar or related actions. And then lastly, it would add a new mechanism for agencies to establish categorical exclusions through a programmatic environmental document, such as a planning process. So for example, an agency could establish categorical exclusions through a programmatic EIS that it prepares for a land management plan. The proposed rule would provide additional clarity on when and how an agency can adopt another federal agency's environmental impact statement, environmental assessment, or categorical exclusion determination, with a focus on ensuring agencies are independently reviewing the documents they are adopting. So an adoption is when one agency prepares an environmental impact statement, for example, to look at an action, and then another agency either serves as a cooperating agency or more often down the road ends up having an action that is substantially the same as the first action. So the example I like to use is the Maritime Administration is funding a project where the Army Corps has already issued a 404 permit and done an environmental assessment, for example. We also proposed a new section on innovative approaches that would encourage agencies to innovate in the NEPA process to address extreme environmental challenges. And then lastly, related to agency NEPA procedures, the proposed rule would require agencies to propose updates to their agency procedures within 12 months of the final rule. And it would add specificity on how agencies establish new categorical exclusions or revise existing categorical exclusions, which would codify many of the elements of CEQ's 2010 guidance on developing CEs. It would also require agencies to do a look back of their existing categorical exclusions every 10 years. And so with that, I will turn it to Rebecca. Thanks, Amy. What button?
Thank you, Amy. Just a note to the rest of the presenters, we're doing good on time, but if you can keep your remarks within 10 minutes, that will give us enough time for questions.
Will do. Thank you so much for having me. Good morning, and thanks for being here today. So I'm here from the Permitting Council, and I apologize. I think somehow the CEQ logo got stuck on my slides, and I swear the Permitting Council is not part of CEQ. I blame Amy, but we'll work with it. So thank you for the opportunity to talk to you all. I want to start with how the Permitting Council helps projects. And it's important for me to mention this because the FAST 41 process is a voluntary process. And so it's good to kind of give the pitch anytime there might be entities with projects in mind. We really offer a lot of assistance to projects. And why does a project sponsor find it compelling to become a covered project? Well, as you heard, there's a lot of work ongoing already, as Amy and Jamie have mentioned, to make the permitting and NEPA process more efficient. However, it remains the case that there can be some real coordination challenges, especially for large projects. And I think to understand this, it's helpful to understand that when you have one project, that may be one project in the mind of like a real world person, but in the federal government, you may have many actions on that one project. It is not just one project from the point of view of an agency that's looking just at the air impacts of that project, or another agency is looking just at the marine mammal impacts of that project. These are each distinct actions that are part of that project, but the agencies are not looking at the entirety of that project necessarily. So, and that, to be frank, is kind of how Congress directed them to act. So what we we come in when a project sponsor says, we're really having trouble coordinating across multiple agencies with distinct actions. And we make sure that the project has a timetable that's agreed to by all of the federal agencies, but also something that the project sponsor has some input into, particularly considering the large role that the project sponsor plays in providing application information and in the project review. We make sure that there is a coordinated project plan. Every agency knows what their role on the project is. We have some early coordination. I like to think about the story of the blind men and the elephant, right? The blind men in this example are the agencies. They each are kind of touching one part, and they're experiencing, they're taking away different information. They see it as something else, right? And the elephant is the project. And so that can be really challenging. Having some coordination can help the agencies to make sure that their roles are coordinated well, and we also make sure that the public is aware of the progress being made. We have a dashboard where we have up-to-date information, and we have a forum for agencies to kind of elevate issues that might be arising. Oh, which one? So we do think that there are a lot of benefits. Just to be clear, we are not waiving any environmental review requirements. You still have to complete all of the permits that would be applicable. But we do think that the increased predictability and coordination really have a lot of benefits. And one thing to mention in particular is that due to the Inflation Reduction Act, we also now have resources, financial resources that we're able to give to agencies to address some of the capacity challenges, which, as Jamie mentioned, is one of the main issues that can cause real delays on projects. Oh, I went too far. That's a sensitive clicker. But so going back to the blind men and the elephant, the Permitting Council, if we could write ourselves into this allegorical story here, we are in the room. We are not touching the elephant, but we do have our eyes open, and we can see a lot of opportunities for how we can improve the permitting process across agencies. And that's sort of what our bigger mission outside of the projects is, to try to be a center for permitting excellence. So some of the things that we are focused on are eliciting from the agencies, what are the best practices that you have done? And can we apply that to another agency? Can we encourage them to use those same tools? What are the common sources of delay? And is that, sometimes those are statutory differences between, definitions between agencies that may not be aligned, or other challenges in coordination, but other times there are real easy solutions to make things more coordinated that we can support. Another main piece that we're focused on is performance measures. As Jamie mentioned, it's hugely important to be able to measure the data, have it be publicly available. And I think that part of it, although there's like sensitivity, I think, for any agency to have their data be public, it's critical to have a baseline to say, okay, the reason that these are taking so long is because we have capacity shortages, or we have this new innovative solution, and what has the impact of that been? It's really effective, let's do more of that. So we think that's incredibly important. We also have a lot of opportunity to advance technology that I'll talk to a little bit more, and then capacity constraints. Because of the funding that we received in the Inflation Reduction Act, we've transferred $160 million to agencies to support the work that they're doing to address permitting and environmental reviews. So those are some of the main things that we are focused on. Let me talk specifically about IT solutions, because we have committed $25 million to agencies to support new tools. And it has been very exciting to see the proposals that agencies have. I think that we are at the cusp of a real moment for innovation and efficiency in the permitting world. So some of the things that have been proposed to us for funding are can we automate some of the easy things? Jamie and Amy have both talked about categorical exclusions. These are by nature the easiest types of environmental reviews, but they can still take a long time. And if we can make those routine actions faster, then you can provide time savings for the 95% of projects that are currently covered by categorical exclusions. That's a potentially huge benefit. And I also think that making easy things easier provides a little more trust from the public that, like, yeah, when you have a really complicated project, it's because this is a complicated action. There are real impacts to it that need to be addressed. There's a lot of interest in digitizing prior environmental review documents. There's a lot of information in those documents that if we have AI kind of absorb all of that information, potentially we could use that as we develop new environmental documents much more easily. Digital mapping, creating GIS maps of where the resources are so that when you're going in for a new project, you can map out what that location is and know what resources have been discovered in those areas that need to be protected or analyzed. Can we avoid them by just picking a different location for the project? Public access to data is a huge issue for project sponsors want to avoid impacts because that makes their life easier, but they're not always able to access that data on where the resources are that need to be protected or that would result in a more complicated environmental review. We also have a lot of interest in kind of having application wizards, like automating the application or having a single portal. And that's a very exciting space. And then again, I already mentioned AI. I think there's a lot of eagerness to figure out what we can do with AI to make this a more efficient and effective process. So look for more to come as we announce the grants, excuse me, for that in the next month or so. So let me talk a little bit about the clean energy context. I think that there's a couple of advantages right now as we look at environmental review. There's tremendous urgency and there is some degree of kind of bipartisan alignment on permitting because of that urgency. There has always been sort of on the Republican side of the aisle a lot of interest in permitting reform. I think that there's new urgency on the Democratic side of the aisle as well. I will say I think that there's a lot more projects that need to be built than we are currently permitting. So I'm not sure that we are quite meeting the moment as much as we need to, but we have kind of consensus that this is a priority within the administration. I will say I think that the prior kind of conception of NEPA and permits is not the easy, it's a little different from how we need to now respond to climate change. We don't have a static environment. It used to be sort of, we had a static environment. We're looking at a project that's being developed for, development or efficient economic growth, et cetera. We're looking at the negative impacts of that project on the environment. Now we have an environment that's changing. We have projects that will have environmental benefits, but they also have construction impacts that are negative, potentially to the environment. They also may have impacts to your species or other impacts that have to be balanced. And so I do think that there's a little bit of additional flexibility needed and kind of recognition of the changing climate context as we look at these projects that's a little challenging, but I'm hopeful that the new rule from CEQ will help us address that. So this is, just to wrap up, I think that two of the things that I'm really excited about are once CEQ releases the NEPA rule, then all agencies will update their NEPA procedures. And this will be the first time in the history of the National Environmental Policy Act that every agency is updating their NEPA procedures at the same time. And it'll be a tremendous opportunity to make sure that agencies are addressing where they might just have different approaches and policies that lead to delays for no real benefit. They just have different approaches. So that reset, I think, is huge. I also think that adopting new IT tools is, again, an opportunity to look at the processes that we have and figure out if there's a new way to do those processes. And I'm very hopeful that we won't just sort of reify those processes into the IT tools, but that's the challenge to manage. So that's my last slide. And turn it over, and I think that was 10 minutes. So.
Good job.
Amazing.
Thank you. Well, let me just say thank you for having me. And I'm Ted Boling. I'm formerly of CEQ, and it is wonderful to follow on after, first of all, Jamie's discussion of the work that we did on trying to figure out, disambiguate how long does NEPA take? and then Amy Coyle, with whom I worked with at CEQ, and Rebecca Higgins, as I was present at the inception of the Permitting Council and was involved in the, standing it up. I spent 15 of my 30 years in the federal government at CEQ, where I did everything from acting chair of CEQ to part-time janitor. But I spent most of my time there working on NEPA, and the reason for that is because NEPA is kind of like the operating system for the federal government. It pervades all the federal agency decisions by design. Everything that has a significant effect on the human environment is supposed to go through a NEPA process. Now, there are exceptions and there are, exclusions, what have you, but generally, when the NEPA process works well, it works well as a means of operationalizing the Section 101 of NEPA, the mandate to, achieve a better relationship between our human environment, our economy, and our natural environment. I have, in the past few years, been particularly focused on renewable energy and the problem of getting renewable energy generated and to market. In that connection, I'm not going to focus so much on Fiscal Responsibility Act. I want to sort of preview for you a report that'll be coming out in April. And I've been authorized by the Niskanen Center and the Clean Air Task Force to talk a little bit about it. And I'll lead off with just at the risk of overlapping with the transmission study, panel yesterday, what I think really captures the importance of the task at hand. Multiple studies have estimated that a 3- to 4-fold increase in transmission capacity is needed to meet the requirements of our time to meet the nation's goals for greenhouse gas emissions reductions. So far, the U.S. has not kept pace with this challenge. In fact, there was an overall decrease in annual transmission investment for large power lines, that's over 100 kilovolts, from 2010 to 2020, and the nation's transmission investment requirements will reach more than $40 billion annually by 2031. There's a huge task at hand at not just generating energy, but also getting it to market. And major transmission projects like SunZia, which is had a preliminary injunction hearing yesterday in Tucson, or the Cardinal Hickory Creek project, which is a client of mine, and I'm not speaking about the pending preliminary injunction motion here, but here's one pending against that. These projects are inherently complicated. They cross multiple jurisdictions. They are necessarily in interplay between federal authorities, state authorities, tribal authorities, local governments. And the Fiscal Responsibility Act amendments sort of double down on the need for speed. But they did that in ways where I'd say the jury's still out, but I'm worried that is somewhat counterproductive. In particular, establishing 1-year deadlines for environmental assessments and 2-year deadlines for environmental impact statements. The challenge nowadays is to get to the starting line, to get to the agency to say, yes, we will issue a notice of intent because we will put ourselves on that 2-year schedule. The Permitting Council exists for purposes of helping to marshal the complicated interagency process, and of which NEPA is really sort of the cornerstone of it all. But I'm finding right now with my clients, and I've been in private practice for all 3 years now, but I've had a lot of interesting experiences. I found, to quote the great Tom Petty, the waiting is the hardest part. You just to get to the point of clarity on, okay, here's what we're doing. We've satisfied, the questions about purpose and need, that we are clear on what are our statutory standards, what's applicable, what's the extent of it, the scoping stuff. There's a sort of pre-scoping, or what we used to refer to as pre-scoping. We, in the 2020 amendment, sort of broadened the definition of scoping to recognize that there's a lot of good work that goes on before you actually enter the formal NEPA process. A lot of good groundwork, with the communities done right. The NEPA process helps foster better decision making, not just at the federal level, but it's an exercise of federal leadership that works for state and local parts. But we have this sort of fear of deadlines now, and that sort of compounds the usual sort of fear of litigation, which I think is overblown. Most transmission lines don't require a significant amount of federal permitting. I mean, there's a nationwide permit for stream crossings that cover most of them. I mean, they could be easy. However, the NEPA process is still important for coordinating and making sure that the federal role and the federal importance of these transmission projects is expressed, is recognized. There are a lot of communities through which the transmission lines pass. The transmission line is just an eyesore. It doesn't benefit the community at all, particularly these large HVDC lines, the high voltage direct current lines. You're not going to be an off-taker from that. You're not going to benefit from that. There needs to be a process for recognizing that and evaluating it. So what we did with the Niskanen Center and Center Clean Air Task Force, we did an in-depth study of 37 lines. We were looking at new transmission lines. We were looking for big ones, over 115 kV, and lines with length more than 5 miles. We're looking at 50 to 200 miles, typically sort of interregional lines. And of these lines, we found that really NEPA was not an impediment there. And only 4 of those lines of the 37 were actually canceled during their pendency. 2 projects haven't gotten along to the point of record decision, but of the 30 that remained, the average NEPA time took 4.3 years, which is consistent with the average that Jamie talked about. Of course, you really do need to talk about median in these areas. The median time is 3.7 because you've got some outliers. You've got some that, some will take a year and a half, some will take 11 years. Of the 17 large transmission lines, and this is, longer than 100 miles and over 345 kV, that the ones that weren't canceled, it's averaged about 4.7 years to get them there. 17 of them completed it within the process within 4 years. We had one where the NEPA process was 1.2 years. But while these projects, the big ones, are only 3.5% of all the transmission line projects that are out there in the database, but they're 26% of the domestic transmission line miles. In other words, the big projects are the big things that you need to focus on. And we found that over half of them did not face any substantial litigation or non-litigation opposition. They didn't have the sort of public campaigns. And part of that is because they use the NEPA process the way it's supposed to be used, to actually engage with the communities, to work out and to basically explain here's why we need a transmission line. Oftentimes they are, just upgrading from existing transmission lines. So we're going to replace your old lattice towers with new pylons. But we need greater transmission capacity. Most of the lawsuits that we found, it's sort of like, APA jurisdiction. I mean, it's arbitrary and capricious standard. The agency generally wins. And that's true with the transmission line case as well. Of the lawsuits that we evaluated, only 2 were resolved in favor of project opponents. And in those cases, I would say 2 so far, because ultimately, you can go back, if you're remanded, get another shot at it, you can come back and try to do it again. But generally, the preliminary injunction motions, like the ones that are pending, resolve in favor of the project proponents. But there's a huge amount of risk in the investment in these projects, and time is money. The project I'm involved in, because of the time and expense considerations, has gone from initially $500 million project to over 650, and it's still not completed. So what you're going to see in the Niskanen report is based on this study, as well as also a lot of outreach, including with the Permitting Council, CEQ, Department of Energy, all the various agencies. We're really focused on the interagency function, making the interagency process work more efficiently and effectively. And for Congress to invest in that, it really does call for federal leadership, from the president, from the executive office of the president. That level of coordination with OMB would be the other part of the CEQ OMB panel. Do you want to be moving the slides? Oh, no. This is not for public display. Okay, sorry. And then in recognizing the central role of the Council on Environmental Quality on conflict resolution, on helping resolve methodological issues that can hang up a project for a long time if you don't get it resolved, if you don't get it elevated. Recognize the importance of the Permitting Council for getting more projects onto the dashboard. Project proponents have been hesitant to put their projects on the dashboard. Usually it's because, well, we're just working at the local level. We don't want to really, put a spotlight on it all, that sort of thing. That's something you say at the outset of the project. 3 years later, you say, wow, we really wish we'd put it on the Permitting Council right from the start. And that's where, I'm advising clients to make use of the authorities that have been provided there. But then there's also this need for Congress to, and particularly in the transmission area, they've sort of dabbled in this area, but we've got a federal system with the Federal Power Act, some authorities in Section 216H, or 216 of the Federal Power Act for sort of backstopping authorities, but they really only come into play when you've got just sort of abject failure. We've got, things have fallen apart. And FERC can step in. That hasn't been used. There needs to be a greater focus on harmonizing the state, federal, and local authorities, and a greater focus on planning for permitting and also for land managers who aren't expert in transmission to basically do what they do best. Figure out where on the landscape this can go. Recognize the biodiversity considerations, the land management considerations, but ultimately not ask, say, the Fish and Wildlife Service to rethink power planning, because that's not their expertise. So with that, I'm going to wrap up. I'm out of time, and I want to make sure that Professor Adelman has the floor. So here you are, sir.
There you go. Okay, great. Thank you very much. Thank you to the organizers. This has been just a terrific conference. I feel like I've learned an enormous amount over the last day and a half or so. What I'm going to be talking about is federal permitting, specifically focusing on wind and solar development. And I'm not going to be talking about all federal permitting associated with wind and solar development. As this slide indicates, I'll be focusing on the Endangered Species Act, the National Environmental Policy Act, which you've already heard a lot about, and the Clean Water Act, and specifically Section 404 wetland permitting under the Clean Water Act. There are other wildlife statutes that are important with regard to wind and solar development. The only reason I'm not covering those is I wasn't able to identify good data for them. This is one of those instances where I'm looking where the light is, where there's some data in this particular instance, and I'm also not looking at the National Historic Preservation Act. So I'm looking at a subset of the statutes that are important with regard to wind and solar permitting. They tend to be, I think, typically viewed by developers as among the most important, and often the ones that are most often implicated by a wind or solar development project. So I'm going to start off with the basic conclusions. What I find looking at wind and solar projects developed between 2010 and 2021 is the vast majority of projects don't require a comprehensive environmental review or an individualized permit. The vast majority of projects either don't require any kind of permitting or environmental reviews at all, or are subject to a relatively streamlined process. Under NEPA, that would be a categorical exclusion. Under the Clean Water Act, that would be a nationwide permit, which is essentially a permit by rule if you meet the certain specific criteria for the particular nationwide permit. Sometimes you have to submit something to the Army Corps of Engineers, sometimes you don't, but it's a relatively expedited process. And then with regard to the Endangered Species Act, typically it's an informal negotiation with the Fish and Wildlife Service. So the vast majority of projects go through those relatively streamlined processes. And so these are the data. So remember, we're looking at wind and solar projects that were developed between 2010, 2021. There were approximately 750 wind projects developed over this period, a little over 100 gigawatts, so both a good number of projects and a significant amount of generation capacity. A little over 1,100 solar projects were developed over this period of time, about 68 gigawatts of generation capacity. One thing I want to note is between 2010 and 2021, this is a period of time where we're beginning to see, it's sort of the early stage of the rapid deployment of utility scale wind projects, and probably solar utility scale really kicks up around the midpoint of the period that I'm looking. So I start relatively early in this kind of latest phase of rapid deployment of wind and solar development, and we're obviously experiencing some variation with wind, but an increasing increase in the amount of solar projects that are being developed today as well. So how have I broken this down? I've broken it down by statute. Again, I'm looking at just EISs, so the most comprehensive environmental reviews under NEPA. I'm looking at just individualized permits under Section 404 of the Clean Water Act, and I'm just looking at projects that require a habitat conservation plan, an HCP, and an incidental take permit under the Endangered Species Act. So in each case, I'm looking at the kind of most rigorous form of permitting or the most comprehensive form of environmental review. So if we look at NEPA, it turns out that roughly less than 4% of projects require an EIS for both wind and solar projects. For Section 404 of the Clean Water Act, it's a little less than 3% of the projects that require an individualized permit. Most of them either don't require a permit at all, or they get one of these nationwide permits. And with regard to the Endangered Species Act, a little less than 5% of the wind projects require an HCP and an incidental take permit, and less than 1% of the solar projects required an HCP or an incidental take permit. So just intuitively, if environmental permitting and environmental reviews were a really overarching or pervasive article to wind and solar development, I think one would expect to see a larger percent of the projects requiring a comprehensive environmental review and an individualized permit, and we're just not seeing that, at least in this kind of first phase of rapid wind and solar development. We can break this down geographically, and so what this map is showing is both an aggregation of all the permits and environmental reviews, again, just looking at the most comprehensive and individualized forms of permits. And I sort of break this down into three areas. There's kind of California, Nevada, and Arizona. Most of that is NEPA compliance and endangered species issues. Florida, where it's mostly Section 404 permits. Other than Alaska, as you might expect, Florida has the largest area of wetlands in the country for a state, and so we would expect that wetland permitting issues would be significant in a place like Florida. And the third area is roughly in the Midwest. Most of this is associated with wind development, and mostly it's endangered species issues associated with endangered bat species. Most of that is driven by white nose syndrome. It's not really associated with wind development itself. So we see both Low volumes of permitting, we see, roughly speaking, maybe 3 hotspots, at least in relative terms. And in areas like Texas and the sort of center part of the country, where we have some of the most rapid and greatest deployment, particularly of wind development, we're seeing relatively few projects requiring comprehensive environmental reviews or individualized permits. So what this map looks at is it looks at data from the project that I did, Matthew at the Sabin Center at Columbia University. They do this wonderful annual report where they look at comprehensively the number or range of projects that have been opposed by local communities, as well as an MIT study that was recently conducted. So it's an aggregation of data, and what it's showing you is the absolute number of projects that were opposed by state and the percentage of projects that were opposed in each state. The coloring only tracks the percentage of projects that were opposed in a particular state. And so roughly speaking, you see kind of a higher proportion of projects being opposed in the Northeast, maybe a little bit in the Midwest, a little bit in the Southeast, although there the numbers are really quite small. If you look at California, one of the themes here is California is kind of an outlier. While the percentage of cases, just 7% is opposed, 25 instances of public opposition were noted there. So the absolute number is actually pretty high. And I would say for project developers, California is generally understood to be a complex and difficult place to develop projects, and usually it takes substantially longer. If you're developing a project in Texas, probably takes you 3 to 5 years. In California, it's probably more like 5 to 7 years, roughly speaking. If we just look at, this is looking, I didn't state this at the beginning, this is looking at public opposition at the federal level, the state level, and the local level. If we just look at the number of projects where we have federal litigation involved, only 12% of the projects for which there was public opposition involved a federal action under a federal environmental law. And those roughly break down into, there were 28 wind projects that were litigated over, 28 cases involving 21 distinct wind projects. Half of those litigations were in California. The rest were mostly in the Midwest. For the solar projects, there were 14 cases over this 12-year period involving 8 solar projects. All of that litigation was in California. And so it's a relatively small fraction of the cases or projects that were litigated in federal court, and it's not evenly distributed around the country. Really disproportionate amount is in California, and then a little bit more, again, mostly around endangered species issues in the Midwest. So just to sort of wrap up, the way I sort of break this down is we've got kind of 2 domains that are roughly mirror images of each other. We've got projects that are on federal land that tend to require NEPA reviews and federal permitting more often by virtue of just having or establishing a federal nexus to begin with. The fact that they're on federal land also means that there are limited options at the state or local level to challenge them. And so if you're going to challenge them, you're going to challenge them at the federal level, often a NEPA case, often a federal environmental statute. Conversely, most of the development actually has occurred on private land, and the vast majority of those projects don't require federal environmental reviews or federal permits, and the vast majority of public opposition is occurring at the state and local levels. Geographically, what we see is kind of hotspots in the Southwest and off the coast on the Atlantic with wind development. Both of those are strongly associated with federal land. To a somewhat lesser extent, at least so far, we see issues with endangered species, mostly bats and birds, mostly associated with wind development, and a lot of that's been in the Midwest. That issue, I think, is changing. The lesser prairie chicken was just recently listed. It has habitat and some of the best wind resources in the country. The tricolor bat is probably going to be listed kind of imminently, and it is everywhere. And one of the things to sort of keep in mind, we often talk about Texas leading the country in terms of wind and now solar development. There are a whole constellation of reasons for that, and one of them is there really haven't been significant endangered species issues, particularly with regard to wind development. And with these recent listings, the lesser prairie chicken, the tricolor bat, that could change. And so I think sort of looking forward, these endangered species issues are one area where there's a potential for there to be greater need for federal permitting and greater impacts associated with federal permitting processes. And so I'll stop there.
There you go. Good.
Thank you, David. That was an excellent set of presentations. I certainly learned a lot about the federal permitting process. We also went over a dizzying array of changes to the federal NEPA regime. So this question came out in various ways in Slido, but are the changes, so within FAST 41, within the CEQ regulations, within the Permitting Council, IRA, resources for agencies, are they enough to expedite our decarbonization efforts? That's the first question. That's a question for everyone. And are they enough to push our decarbonization efforts in a way that balances other things that we care about, like endangered species preservation, climate justice? And if not, what reforms would you propose?
All right, well, I'll lead off with, first of all, I think it really matters who is involved, what individuals. I mean, I think, the vision of a permitting system is, you have agency order and regularity. But, part of the problem with some of our permitting decisions is they work down to sort of idiosyncratic, the perceived needs of particular offices. And you can have a great variation amongst even within the Army Corps of Engineers or the Fish and Wildlife Service or something like that, and frankly, a need for elevation, regularly weighing in on how we're making these permitting decisions. I think with IRA, with Inflation Reduction Act and the Infrastructure Investment and Jobs Act, we have the best set of tools we've ever had. I mean, if we can't do it now, it's shame on us. But part of it is just making sure that we've got things sort of dashboarded, that we've got, if everything's a priority, nothing's a priority. Making clear as to what needs to be moving forward at what time, and really focusing on bringing those projects to bear. I think the announcement yesterday of the South Fork Wind Project is a great example of where working through interagency issues, very complicated ones. We've never built industrial scale wind power projects off the coast of the United States. Working through the complicated marine environment issues there, that it can be done, and having the Secretaries of Commerce and Interior there at the announcement to affirm this is a good thing, team. We need to do more of this. That's the key.
Yeah, I'll just second the note of optimism that I think I heard there. I mean, there is no question that this is a real challenge. We have new industries, many of which are being led by applicants that are not necessarily traditional applicants for federal funding or very familiar with the environmental review process at the federal level. That poses real challenges, as does just the volume of funding, which is a great challenge to have for federal agencies, but it is a real challenge in terms of the capacity. However, the addition of funding for environmental review that was provided in the Inflation Reduction Act, I think will make a huge difference. And I think that the administration is focused on this challenge. So I am very bullish about our ability to meet the challenge. I think that the Permitting Council is kind of standing up to say, government can do this. We can can build big things. We can meet major challenges. We've done it in the past, and we can again. So it's a very exciting time, and I do feel quite bullish about our prospects.
I think that I'm going to add one additional piece. When we think about having agencies make quick decisions, one of the things we need to recognize is the ability for them to look at a situation, look at potentially conflicting responsibilities, and make a decision. And so while we have these increasing number of tools for agencies to move quickly, to expedite procedures, to streamline laws and requirements, I think that there's also room for Congress. And one thing that I'm concerned about is that I actually think there's a third element of agency capacity. So if we say it's enough staff, it's enough expertise, and then the third piece is that it's enough discretion. Agencies have to have the ability to make a judgment call. And we have a trend coming from the Supreme Court that is reducing that discretion. So right at the time we're asking agencies to do more, to make quick decisions in a regulatory environment and a factual environment that's extremely complex and evolving, we are taking away that third element of discretion if we limit, that third element of capacity if we limit their discretion.
Great. David, anything you want to add? Okay, so the second question is, are there any lessons from the federal permitting of fossil fuel infrastructure that the renewable energy transition might be able to learn from, rules on natural gas permitting, for example?
I haven't studied that, so.
I guess the only thing, this is not really a lesson, but it is an interesting challenge. A lot of our offshore wind projects are being built by major oil companies, Shell, BP. These are some of the major players in the offshore wind. They are familiar with building things offshore. It's oil rigs previously. It's quite different because the fossil fuel industry has successfully gotten some exemptions to certain environmental review laws. That means that it is now a different process and potentially a more rigorous process for building offshore wind than it is for building offshore oil drilling. And it's challenging not only because they're being held to a different standard, but also the applicants are unfamiliar with the process that they've sort of lobbied themselves out of in the oil context. So that's not exactly a lesson learned, but just an observation.
Well, I'll just sort of build on that. So, say in the Gulf of Mexico, they thought they'd had everything pretty well figured out, and they had, their relationships with Bureau of Ocean Energy Management, then the Minerals Management Service, and the National Marine Fisheries Service and such. But off the coast of the Atlantic, it's a whole new beast, so to speak, in terms of you have North Atlantic right whale, critically endangered whale. It's down to like 350 individuals, all descended from 8 females. Right on the edge, and a new set of biologists operating out of GARFA, the field office up in Gloucester, Massachusetts, and the BOEM, the Bureau of Ocean Energy Management, is a stranger to this area, and then their challenge is to link up to a power system that PJM, NYSERDA, the New York ISO or New England ISO, which hasn't planned in this power. And so it's hugely complicated, like 3-ring circus of decision making and interrelationships there. And so I think it's actually much more complicated, but one of the things the oil and gas industry had in favor of it was a sort of imperative to drill. The Outer Continental Shelf Lands Act was structured in terms of 5-year plans, and you're going to, offer leases on schedules, and the leases provide the right to drill. The offshore wind paradigm is completely flipped. Your lease in an offshore wind context is only the opportunity to go out and explore the area for 5 years and then come back with a construction operation plan for proposal. You have no rights associated with that, and you're basically begging every agency to go ahead and approve your project, including state agencies. So it's a much more complicated exercise legally for Bureau of Ocean Energy Management to lead. And what BOEM has to do is a fairly Herculean task of beg, borrow, cajole, and convince and lead along the way. And I'm worried about burnout at BOEM. I mean, I have seen the people I used to work with on just, regular interagency calls. I mean, they've been fried. And yet it should be, a national imperative that we are actually moving forward with this agenda.
This is a question for David and Ted. To what extent are the existing streamlining processes, particularly exemptions, exclusions, general permits, effective triaging of our limited agency resources, or are they just covert deregulation? Is there a risk of that?
I think it's a great question. And the simple answer is we just have so little visibility into the informal negotiations with I'll focus on the Fish and Wildlife Service, because that's where most of this goes on. And so the short answer is, at least empirically, we don't know. Anecdotally and kind of structurally, my sense is that informal negotiations actually work pretty well. But it's really because of the distinctive features. I'm here just focusing on wind and solar development, nothing else, where I think the dynamics are really different. In the wind and solar sector, both the developers themselves are really committed to mitigating any kind of environmental impacts, especially on endangered species, especially on prominent endangered species. To get financing, often the financing entities are very, very conservative with regard to environmental issues and environmental due diligence, and they really, really care. They don't want to have a project that is killing golden eagles or something like that. And then in addition to that, often the off-takers, the entities like Google and Apple who are purchasing the power, also care about the environmental characteristics of these projects. And so for all of those reasons, you have kind of an alignment between the interests of the developers and the interests of the regulator in this case. And that sort of ensures that there's meaningful mitigation on the part of the project developers, or they move the project, or they change its operation. I would say, my sense, in part because of the leverage that Ted was talking about, there are times when just to get agreement with the regulator, and in part because there's such big variation across different offices within the Fish and Wildlife Service, project developers will agree to things that, at least in my humble opinion, I'm not sure are always warranted. And that's in part because of risk aversion within the federal agency, and particularly litigation. Well, actually, in this case, not so much litigation aversion, but just risk aversion generally. So I think in this particular discrete area, it works. I'm not as convinced that it would work in other areas where you don't have that alignment of interests, that all are committed to minimizing and mitigating the environmental impacts of the projects.
Great, thanks, David. Speaking of deregulation, someone in the audience asked this very pertinent question. What changes in procedures and policies, if any, would you expect if there is a change in the national leadership in this fall's election to the federal permitting scheme? And what can we do about it?
Amy? Okay, I was being puckish there because that's not a question for the government officials. I've got some scar tissue there, but during the all right. So after the 2016 election, I was telling the CEQ staff, it's like, have heart, the machinery of government goes on, and we will, and I was doing my deep state kind of speech. And we and I do believe, I mean, I was part of the federal family for 30 years, and I do believe that, the laws, the institutions, that there's a certain durability there. And that's to be embraced and respected. I mean, I came away from my experience up through 2020, really, convinced in the power of rule of law, and very happy with the effort that Amy and I were involved in doing the update to the CEQ NEPA regulations with a limit to the amount of craziness that got introduced into it. One federal official, who's now known as co-conspirator number 4, certainly had his impact on particularly cumulative effects regulation. But ultimately, I'd say 80% of what we were able to do was actually pretty good updates and such. And what CEQ is working on is trying to improve that. And hopefully what comes out in the final rule will actually represent such an improvement. But I think, the laws and the people who administer the laws, and that, having a senior executive service, having some staffing that's regular. It's not just, people you hire off the street to come do a job, but really can take the long view and learn about, projects and what's involved in decision making, what works, what doesn't, what's a good mitigation plan, what's not a good mitigation plan, what's got a nexus to environmental effects, and what's just political, walking around money. That's a real skill set. It deserves to be supported.
I guess I'm a political appointee, so I guess I should be able to speak to this question more freely than others. I think that, I will say the laws that we have that govern the environmental review process, like Ted said, are fairly durable, and I don't envision a change in the leadership of Congress that would get to a filibuster-proof majority in the Senate. So I think that it is not likely that we would have a permitting reform bill that would completely change the structure of our environmental review laws. That said, I think that the administration has a lot of agenda-setting ability. As I've talked about, this administration really has put a priority on how do we address the capacity shortages in agencies and ensure that we are positioning ourselves to be able to achieve the decarbonization goals that the administration has set. I think if you look at the Trump administration from 2016 to 2020, they certainly had a kind of a sector priority. They had some strong concerns about offshore wind. The offshore wind projects that were on the permitting council's covered project were sort of paused at that time, and we had to play a lot of catch up to kind of get them to move forward again once the Biden administration came in. So I think that there is a lot of ability to, through like setting agency budgets and prioritizing resources towards different functions within an agency or between agencies. That's the way, in a traditional world. I mean, if I don't know where democracy stands, so that's sort of a bigger question, but within a traditional view of what powers a president has, there are quite a number in terms of agency priority and budget setting.
On that tentatively optimistic note, I have to end the panel because we're 2 minutes over time, but I wanted to thank all the panelists for a wonderful discussion, and the audience for coming, and the Stegner Center for putting this on, and Jamie especially for organizing this panel.